arises that the man has retired, what will happen?
So for that purpose, you have to overturn Afia Sherbanu Zia. For those purposes, you have to first, this court has to overturn Afia Sherbanu Zia in order to cross that barrier and then go to
this case is slightly different. He was not retired at that time.
That's right. He was still before the court. Now the question would still be that if the petition is allowed, what could be the consequence? Now if limited consequences
जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका,
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he is corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports, whatever, remove him. He's removed. Now, naturally, when he filed the petition, he's already stand retired.
That's right.
So I don't think the date would there be, he has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad, whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has...
इसका solution क्या है फिर?
So इसका solution to my mind
is... आप कह रहे हैं कि इसको club करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And
nobody could have thought this would connect there.
So 3 years.
So if he had 3 years to a service left.
No, like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously,
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by.
Because that delay we are accountable for. That's in this particular case. Because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not. Nobody can.
So, कितनी hearings हो गई थी इसमें?
बेशुमार सर, many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं है, हमने कितनी दफा सुना इस केस को?
दूसरा मैं आपको ऑर्डर शीट दिखाऊं तो
ये दूसरी दफा है, हम मेरे साथी याद दिला रहे।
But we are responsible for our seniors.
अक्टूबर 2018 में ये पिटीशन फाइल
2000
नहीं वो क्योंकि वो पार्टी नहीं बनाया था ना, उसमें भी टाइम लगा। वो आपका कसूर था खान साहब, थोड़ा हमारा कसूर था मगर वो आपका कसूर था, मान लीजिए। क्योंकि आपने एलिगेशंस लगाई थी अगेंस्ट पीपल हु वर नॉट बिफोर, सो वी हैड टू गिव देम अ नोटिस। सो वो दैट गोज इन योर, वी डोंट एक्सेप्ट रिस्पांसिबिलिटी फॉर दैट। जी
But the question that even shows that this was a case.
साबिक जज इस्लामाबाद हाई कोर्ट शौकत सिद्दीकी बरतरफी केस की समाअत। शौकत सिद्दीकी के खिलाफ ऑर्डर में तासुर मौजूद है कि उनके इल्जाम दुरुस्त नहीं। हाजा हारिस के ऐसे दलाइल आए सामने।
Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through the studying it properly, because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. Once the matter is before your Lordship also has the power to do complete justice under Article 187. So there is no impediment.
आपकी अपील कब लगी है?
My Lord, it's been filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office fixes it.
साबिक जज इस्लामाबाद हाईकोर्ट शौकत सिद्दीकी बरतरफी केस की समाअत। रिटायर्ड जज के खिलाफ सुप्रीम जुडिशल काउंसिल में कार्रवाई के इख्तियार का मामला। विफाक ने कार्रवाई का इख्तियार खत्म करने वाले आफिया शेरबानो केस में अपील दायर कर दी है। अटॉर्नी जनरल ने अपील दायर करने से मुतालिक अदालत को आगाह कर दिया।
Any of the council or
This is one of the exceptional cases. Earlier cases, like Justice Shaukat Ali's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases, Ikhlaq Hussein's case, where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore, my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases, where inquiries were held?
One is Justice Shaukat Ali's case is PLD 1971 Supreme Court.
1971 Supreme Court.
Page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
recommended the judge's removal. And in the next case is, this is Justice Shaukat Ali.
Earlier case was Justice Ikhlaq Hussein's case, PLD 1960 Supreme Court. Yeah, page there, 26 perhaps.
जी
अच्छा उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे, चलें खैर अगला वाला बताते हैं। कोई और भी केस है?
ये दो केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। अब सर एक और बात, 1956 का मैंने कॉन्स्टिट्यूशन एग्जाम देखा है, उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच, बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
60, under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution.
किसमें नहीं था?
ये इसमें नहीं था अखलाक हुसैन वाले केस में, स्टेट वर्सेस अखलाक हुसैन।
नहीं, वो कौन सा आइन था जिसके आप जिक्र कर रहे हैं?
56 का।
उसमें नहीं था?
उसमें ये नहीं था कि इंक्वायरी जरूरी है।
उस आइन की कौन सी शिक थी?
उस आइन की शिक थी आर्टिकल 169। 169।
अच्छा 169। अच्छा इसमें नहीं था।
उसमें अब आप ये I read that out.
No inquiry required. हाँ जी।
A judge of a high court shall not be removed from his office except by an order of the president made on the grounds of misbehavior or infirmity of mind or body. If the Supreme Court, उसमें Supreme Judicial Council नहीं, Supreme Court ये function करते थे. If the Supreme Court, on reference being made to it by the president, reports that the judge ought to be removed on any of those grounds. ये Article 169 था उसमें. और इसके बावजूद भी डिटेल इंक्वायरी की गई थी उसमें, और डिटेल इंक्वायरी
अखलाक हुसैन का केस था तो 56 कॉन्स्टिट्यूशन वाज अंडर कंसिडरेशन और द 60 कॉन्स्टिट्यूशन
अंडर द 1956 कॉन्स्टिट्यूशन।
अच्छा, मगर उसके बावजूद भी इंक्वायरी हुई
थी। सो मेरी गुजारिश ये है कि दिस इज द फर्स्ट केस ऑफ इट्स नेचर वेयर ए जज is removed without inquiry. will have a repercussion for the future, because judges of the Supreme Court has no other security available to him except that a Supreme Judicial Council makes inquiry into the allegations. If that is taken away from him, then he is left on the mercy of the person who alleges against him, whether he is president or whether he is any other person making a complaint. So therefore, my submission is that a detailed judgment is required to give why inquiry is so necessary in cases where the allegations against the judge of the superior courts, for which there cannot be any recommendation for removal without holding a proper inquiry into it and giving a statement of allegations. Even in the case of Ikhlaq Hussain, there were 3 allegations, specific allegations made. Similarly, in case of Sheikh Shaukat Ali in 1971, specific allegations were made against him, on which inquiry was held. In here, no statement of allegations were ever given to the petitioner, and naturally,
और भी केस था ना वो खान साहब वाला
जी,
एक और भी केस था ना, वो रिपोर्टेड है या नहीं है?
ये दोनों केसेस तो
फजले गनी खान साहब का कोई उसमें केस चला था या नहीं चला? चला नहीं था
इनका,
नहीं चला था,
No, sir.
खान साहब एक बात बताएं, आप इसके अंदर तो एलिगेशन डिफरेंट है शौकत अली साहब वाले में और